Hey everybody, welcome back to Kelly's Take Two Pre-Licensing Zoom review. It's great to see you once again. And the other day we left off, with the other session, we left off examining the standard offer to purchase Form 2T that is widely used in North Carolina. It is the form that you will be tested on for the state exam. And it is one that is put together by the North Carolina Association of Realtors in partnership with the North Carolina Bar Association. So that's quite a bit of brain power right there. So I'm saying, hey, let's kind of go with that. All right. Before we dive back in, we're going to pick up on page 5. That's where we left off. And just as a quick reminder, while this is the form that 99.9% of realtors use, you will have access to this form and hundreds of others if you choose to become a realtor, which is optional. But as one, you will have, like I said, access to all of these forms. If you choose to not become a realtor and remain a real estate agent, you will need to hire an attorney to help put these forms together. On that same note, as a realtor, every now and then you might end up working with a client who really dislikes our standard Form 2T, and that's okay. They just need to hire an attorney to put together their own contract form. The contract form needs to contain 19 items. A lot of them, like I've mentioned before, are kind of no-duh items. Oh, we have to name the parties of, okay. Oh, we have to put the price in there. Okay, let's do that. But two things that will never be included in a contract, not a standard contract, but a contract in general, sales contract, would be anything about the real estate broker's commission and nothing that could disclaim a broker's liability. All right, and with that tiny introduction, let's dive back in. Here we go. On page 5, we're going to pick up here. Let me share my screen with you. I tried to make it gigantic so you could see it really well. Wonderful. And okay, so we're on page 5, I do believe, and we're on number 3, the third provision. The third provision says what? It says, it's talking about personal property. So the following personal property present on the property on the date of the offer shall be transferred to the buyer at closing at no value. So things like that could be the washer and dryer. It could be a sofa, bar stools, who knows what. Occasionally a lender wants that to be blank, wants that to just say NA, in which case you might put together a separate document, something like a bill of sale with zero value or depending. But occasionally a buyer will want to purchase some personal property from the seller. And to accomplish that goal, again, you could use a bill of sale to accomplish that if the buyer is going to pay the seller for the personal items. Otherwise, if the personal items are going to transfer to the buyer at no cost, you could write them here in number 3, as long as the lender is okay with that. All right, here we go. Let's keep going. All right, let's talk about number 4, the buyer's due diligence process. Remember, the due diligence frame is, for all intents and purposes, like an inspection period. So the buyer and the seller will negotiate a certain time frame during which the buyer can investigate the property and contemplate whether or not they want to proceed with this contract or back out of this contract. It's up to them for any reason or no reason. That's how it rolls out here in North Carolina. If the buyer decides to back out of this contract, they will get their earnest money back, but not the due diligence fee. All right, so a big red warning box. Woo, that's there to get our attention. So let's read it. What does it say? Let's go. And here we go. Warning, a buyer is strongly encouraged to conduct due diligence during the due diligence period. If buyer is not satisfied with the results or progress of buyer's due diligence, buyer should, look at this language, terminate this contract. When? here we go. Here's your deadline. Prior to the expiration of the due diligence period, unless buyer can obtain a written extension from seller. Okay, this is important. Watch this. Seller is not obligated to grant an extension. Ooh. Although buyer may continue to investigate the property following the expiration of the due diligence period, buyer's failure to deliver a termination notice to seller prior to the expiration of the due diligence period will constitute a waiver by buyer of any right to terminate this contract based on any matter relating to buyer's due diligence. Provided, however, following the due diligence period, buyer may still exercise a right to terminate if seller fails to materially comply with any of seller's obligations under paragraph 8 of this contract, or for any other reason permitted under the terms of this contract or North Carolina law. So what that means essentially is once we pass that due diligence date is a hard date. It's a time is of the essence date. So let's say for an example, let's say the buyer and the seller are negotiating home repairs, which by the way are optional, but let's say they are. And let's say the buyer has asked the seller to complete 5 home repairs. Well, we're coming up on this due diligence date. We're on the date. We have until 5 p.m. to decide what we're going to do as the buyer. Let's say the seller has completed 3 of the 5 repairs, and we haven't even gotten the seller to agree to do the other 2. We haven't quite negotiated that completely. If the buyer just lets it ride and they go to the day after their due diligence final date, then they have no more leverage against the seller for those repairs. They have no carrot, they've got no stick, they got no nothing. So it's really important to make sure that the buyer is doing everything they need to do in terms of negotiating for repairs, in terms of getting their loan through the final approval process, et cetera, before that hard deadline. Because once we're past that hard due diligence deadline, 5 p.m. on whatever date, if the buyer backs out, the buyer will be in breach of contract, and there are consequences for that. Okay, very good. Now it says here, the buyer may exercise the right to terminate if seller fails to materially comply. Well, what would that look like? Well, materially means big time, first of all. So if there is a cloud on title that's been discovered and the seller can't clean that up, can't clear it, then that would be a situation that would render this contract voidable, and the buyer could decide whether or not they want to back out, void the contract, or move forward. That's an example. Another example is if the property is destroyed. So the buyer has the right at that point to back out, void the contract, or move forward. And we'll get to that. That's under a provision called risk of loss. So that's a good one. So we'll go over that too. Okay, let us keep going. Next, the buyer's due diligence process. This is where the buyer is being advised to make sure that they can get their loan approved if they are going to get a loan. All right, and this is where it says right here, note the buyer should make sure with the lender that they are able to get this loan processed all the way through underwriting and completely approved prior to the end of the due diligence period. All right, next, letter B, moving on, is a list of inspections that the buyer is being advised to complete. Now, people, can we talk here for a minute? This should not be the first time your buyer sees this list of inspections that they ought to complete during the due diligence window. This needs to be discussed with your buyer day one, right up front during your 90-minute buyer consultation meeting. That's when you need to go over all of these. So I'm just going to hit these really fast. All right, so your buyer is going to be advised in this contract form to complete all of their inspections. Review any pertinent documents, covenants, conditions, and restrictions, so on and so forth. Make sure that they can obtain hazard insurance or home insurance on the property. Have the property appraised. It's advised that they have a survey completed. It's also advised that they should double check zoning and governmental regulation to make sure that they can do with the property what they would like to do with the property. They should make sure that the property or verify whether or not the property is in a flood hazard area. Check on utilities and access. Check on roads. Are they publicly or privately maintained? And it says right here that you might want to double check that. If the claim is that the roads are publicly maintained, you may want to call North Carolina Department of Transportation. Additionally, your local municipality as well. Next, the buyer is advised to check on special assessments that may be under consideration that the buyer could be responsible for in the future. And then to conduct an inspection of the fuel tank and determine who owns the fuel tank, where it's located, those sorts of things. Okay, very good. The note box simply says, when it comes to the fuel tank, we need to know, may the buyer continue the lease if it's being leased, so on and so forth. All right, moving on to letter C. What else should the buyer investigate during their due diligence window? Well, it says here that if the buyer has another home to sell, what should we do about that? So let's read letter C together. It says, as noted in paragraph 5B, unless otherwise provided in an addendum, this contract is not conditioned upon the sale or lease or closing of other property owned by buyer. Therefore, if buyer must sell or lease other real property in order to qualify for a new loan or to otherwise complete the purchase of the property, buyer should seek to close on buyer's other property prior to the end of the due diligence period, or be reasonably satisfied that closing on buyer's other property will take place prior to the settlement date of this contract. There you go. Okay. Now let's go on to letter D. Letter D is a good one. This is about repairs. I have had agents who've been in business for many years call and ask me about this provision. So let's go. So repair, it's called Repair Improvement Negotiations and Agreement. Buyer acknowledges and understands that unless the parties agree otherwise, look at this, look at this, look at this, here it comes. The property is being sold in its current condition. Buyer and seller acknowledge and understand that they may, but are not required to, engage in negotiations for repairs to the property. Buyer is advised to make any repair requests in sufficient time to allow repair negotiations to be concluded prior to the expiration of the due diligence period. Any agreement that the parties may reach with respect to repairs shall be considered an obligation of the parties and is in addition to this contract, and as such must be in writing and signed by the parties in accordance with paragraph 19. So once you have your repair agreement worked out, both parties have agreed to it, they've signed it, it becomes a material part of this contract, and the parties need to perform. So let's go back to our previous example where we said we had a seller. We were trying to negotiate 5 repairs with a seller, and the seller at the time would only agree to 3, and we were still trying to get to agreement for the 5. Let's say that the seller does agree to all 5. They agree to it, but now it's almost time to close the property, and they're not all done. 2 of them are not finished yet. What is the buyer to do? Well, the buyer could sue for performance, could sue for specific performance of the contract if we don't get those 2 items completed. Now, nobody wants to go to court, right? You're going to find a way to work it out, hopefully. But technically, for test purposes, the buyer could sue the seller for specific performance. Hey, seller, Do specifically what the contract says, and it specifically says you agreed to fix these 5 repairs. Let's get on the move and get her done. You just hope you don't get to that point naturally, but technically you could. Okay, letter E, I'm going to hit this just very quickly. Letter E, just to summarize, it says that if the seller's property is damaged during inspections, and the inspections were hired by the buyer, that the buyer will be responsible for repairing that damage, shall we say. It also says that the buyer will hold the seller harmless for any injury that might occur on the property during inspections. All right, letter F, let's go up to letter F and then we'll come back to letter G. Letter F is a quick paragraph I'll just summarize for you, where it says essentially that the buyer will hold the seller harmless for any injuries that might occur to the buyer's inspectors, so on and so forth. So we're not going to sue the seller for injury that may occur during inspections. Letter G is a good one, so let's slow down for G. G is the buyer's right to terminate. Provided that buyer has delivered any agreed upon due diligence fee, buyer shall have the right to terminate this contract for any reason or no reason by delivering to seller written notice of termination during the due diligence period or any agreed upon extension. Time being of the essence. If buyer timely delivers the termination notice, this contract shall be terminated and the earnest money deposit shall be refunded to the buyer. Remember, the seller keeps the due diligence fee. Letter H simply says, closing shall constitute acceptance of the property in its then existing condition unless a provision is otherwise made in writing. Let's keep going on. What does the buyer represent? The buyer represents the following. If we're paying cash for the house, okay, let's check it out. Buyer represents funds to complete the purchase. Check this box if we are paying cash. Buyer intends to pay cash in order to purchase the property and does not intend to obtain a loan or funds from sources other than buyer's own assets. Verification of cash available for settlement is it attached or it is not attached? And then we're given a little warning note here in the box. Let's check it out. It says, if buyer does not intend to obtain a new loan and or funds from sources other than buyer's own assets, seller is advised prior to the signing of this offer to obtain documentation from buyer which demonstrates that buyer will be able to close on the property without the necessity of obtaining a loan or funds from sources other than buyer's own assets. And we call that proof of funds. So what you're going to ask for would be proof of funds from this buyer. All right, now, if the buyer is not going to pay cash, then what are they going to do? Let's find out.